Meyiwa murder trial, which is continuing in Pretoria today. Everyone's talking about this Docket 375. Let's head over to Slindelo Masikane to get more details on this. And hello to you, Sli. I suppose the issue is going to be about the authenticity of this Docket 375, and also we have to talk about jurisdiction as far as the courts are concerned. Good morning. Let's start with the docket. What do we have?
Well, in terms of the authenticity of the docket, a letter was submitted by the NPA saying that it was actually a document that had no merit and was an opinion of a junior advocate within the NPA. So what we're expecting really to canvass more of today is that issue around jurisdiction. But I want to get straight into some analysis. I am joined by Marius du Toit, legal expert. Thank you so much for your time this morning. Let's start with this opinion by a junior advocate in the NPA, and the NPA saying that Docket 375 has no merit. But we know the defense is saying we don't accept this. We still want to cross-examine the state's first witness with regards to this docket.
Well, first we must remember that the defense is entitled to a full disclosure of the evidence and the conspectus of the evidence against the accused. Now, if there is a docket that contains any evidence that's relevant to the trial, the defense is not only entitled to it, but they should have it.
Yeah.
If they don't have it, you can talk of a trial by ambush. If there's evidence inside this docket that could prejudice the accused and was not disclosed, whether purposefully or negligently, it can definitely prejudice the accused in their defense.
Yeah.
And to then say, well, listen, I've received this docket, I want to re-examine a witness that was called by the state. If that is in fact the truth, that I've only received the docket now and this does has a bearing on the first witness, then absolutely the witness should be recalled so that he can be tested on the evidence in this docket. So I am in agreement with the defense that if this docket was not disclosed, then they're entitled to say, listen, we want to peruse this docket, we need some time to go through it, and then based on that we will reassess whether we want to recall any witnesses of the state. Because a full disclosure, Slindelo, should have been made. Yeah. This is what should have happened.
Yeah. So now we're also canvassing an issue around jurisdiction. The defense, in particular, Advocate Diffo, saying that due process was not followed and questioning the authenticity of a signature by the NDPP authorizing this court to oversee it.
Now, firstly, you must remember, when a matter comes from Vosloorus, where this offence was committed, Palm Ridge would be the High Court in the South Gauteng division that would be hearing the matter in the normal course of events.
Yeah.
But the NPA, by virtue of the head thereof, has the authority to designate in terms, I think, Section 22 of the NPA Act, to say this matter must be tried in a different division. So first and foremost, if there is such a direction, which we understand there is, then the Pretoria division has the authority to hear it. But keeping in mind that the Gauteng division consists of two courts, being Johannesburg and Pretoria. And it's for convenience that the matters are often heard in Joburg, and for convenience that it's often heard in Pretoria, because they have the same jurisdictional area in essence. So it doesn't really matter whether it's Pretoria or Joburg. But then if you take it one step further, if there is such a direction by the NPA, well, then the matter must be heard here. And then lastly, in terms of the Criminal Procedure Act, Section 110, it clearly states that if an accused has pleaded, whether guilty or innocent to the charge, and it then is discovered later on that suddenly this court is not vested with jurisdiction, it is deemed that the judge has jurisdiction to hear the matter. So this is actually a moot point. It has no bearing on the matter. Yeah. I don't see the court will entangle itself too much with this arguments, and I believe that this court is the court that should hear the matter based on that, because it was not pleaded.
Yeah. Mr. du Toit, let's talk about how the court is going to balance the rights of accused 5 against the rights of accused 1 to 4. 1 to 4 want a speedy trial. Accused 5 still needs time to peruse Docket 375.
So when one looks at any trial, there's a number of constitutional rights that kick in. One, a right to a fair trial, a right to a speedy trial, a right to test the evidence. So there's a number of aspects that should be considered by the court. And the court should strike a delicate balance between all the accused constitutional rights, not emphasizing one more than the other, but having regard to the fact that a docket has only been disclosed now. That goes to the heart of a fair trial. That goes to the heart of the fact that the accused should be entitled to test evidence that exists. So I can't see that the court will say, listen, I'm going to prejudice number 5 in his preparation for trial if this was only disclosed at this late hour, to suddenly say we can't have a postponement for that purpose. So the right to a fair trial and the right to a speedy trial, these rights aren't absolute.
Yeah.
But the court has to strike a delicate balance, and I can't see that the court will, in this matter, say, listen, now we're proceeding with the one against the other, or we're proceeding in the absence of the other. That won't happen. So it's either all five together, and either in the interest of justice, the matter will proceed in September, or the interest of justice will cause the matter to be, the postponement to be declined and the matter to proceed on the same day or on an earlier date.
Just lastly, quickly, if you could just give me your analysis of how the interaction between the judge as well as Advocate Tiff in particular is playing out in court and what kind of effect it could have on the trial. And also, has the defense laid the ground for a possible acquittal in terms of how we're seeing this trial unfolding?
Okay, firstly, I think it's too early to talk about the acquittal when we haven't heard all the evidence. Remember, only at the end of the state case are you in a position to say, is there evidence upon which a reasonable court might convict? So we'll only be able to make that finding once we heard all the evidence. In respect of the way the attorneys or advocates have conducted themselves, it's important for any accused or attorney to have the atmosphere of the court in their favor. And by that I mean, you don't want to unnecessarily engage the judge in an argument about everything, because at the end of the day you are prejudicing your clients. I'm not saying that clients don't like the idea that the attorney is vocal and he stands up for their rights and he fights in court, because we understand it's an adversarial environment where you're operating. But the reality is, at the end of the day, you don't want to argue about each and every aspect, and you don't want to engage the judge. You don't want to have a situation where people think, well, listen, you are just arguing with the judge for the sake of arguing, and at the end of the day, if you do that, the atmosphere of the court will not be in your favor. So it's a delicate balance that any attorney or advocate strikes. Is number one, they don't just want to engage the judge and to be seen as trying to frustrate the legal process, to waste the court's time, to stand when you're not supposed to stand, to ask for things you're not supposed to get. Because at the end of the day, you're just going to have the judge say no all the time to you, and that's not going to help you.
Thank you so much. We've run out of time, but I would have hoped to peruse some more issues, but hopefully we'll get you back sometime next. Thank you so much. That is the latest here from the North Gauteng High Court. Of course, court proceedings starting at 10 a.m. this morning, and just some analysis ahead of that in terms of what we're expecting with the issues around jurisdiction and, of course, the manner in which the defense is conducting itself inside court.
Yeah, that last point I think is particularly interesting, isn't it? I'm sure we're going to get your guest back on to talk about that. Slindelo Masikane outside the Pretoria High Court for us. Back to her again later in the morning.